Good morning and welcome to the Public Service Commission of South Carolina. It is Wednesday, April 5th at 10 a.m. We are here today for proceeding in docket number 2022-359-A. Let's take a roll call of commissioners. Present in the hearing room, we have Commissioner Justin Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Carol Lee Williams, Commissioner Caston, and Chair Belser. Commissioner Irvin is on leave today. Mr. Stark, would you read the docket, please?
Yes, ma'am. Thank you, Madam Chair. Madam Chair, the Commissioners, we're here for the proceeding in docket number 2022-359-A. This concerns the review of Chapter 103, Article 3, Electrical Systems, South Carolina Code of State Regulations. Madam Chair, this proceeding has been scheduled for Wednesday, April the 5th, 2023 at 10 a.m. in the offices of the Commission. Madam Chair, I believe the proceeding is ready to move forward.
Thank you, Mr. Stark. Let's take appearances of parties or anyone that's here today. Duke Energy Carolinas and Duke Energy Progress.
Morning, Madam Chair.
You're not on. There you go.
Morning, Madam Chair. Lyle Trawick of Robinson Gray on behalf of the companies.
Thank you, Mr. Trawick. And Dominion Energy South Carolina.
Good morning, Chair Belser and members of the Commission. My name is Chad Burgess. I'm in-house corporate counsel for Dominion Energy South Carolina. And with me today is Michael Anselmo from the law firm of McGuire Woods, and together we represent the company in this proceeding.
Thank you. Lockhart Power Company.
Good morning, Madam Chair, Commissioners. I'm Peg Fox with the law firm of Byrne Foreman, here representing Lockhart Power. And I believe my client, David Turner, the business controller for Lockhart Power, is participating virtually.
Okay. Welcome, Mr. Turner. Thank you, Ms. Fox. And Office of Regulatory Staff.
Thank you, Madam Chair, members of the Commission. My name is Ben Muschin. I'm an attorney with the Office of Regulatory Staff.
Okay. Before we get started, I think y'all know the routine. You're welcome to remain seated when you make comments. You may go to the podiums if you like. We just need to be able to hear you. So just please make sure that you're able to talk into the microphone. But I want you to be comfortable with your comments. Good morning, Ms. Boyd.
Good morning, Madam Chair. I'm Jocelyn Boyd, employed by the Public Service Commission. And Madam Chair, if it's okay with you, I'd like to proceed with asking that certain jurisdictional documents be made a part of today's record. Ms. Adams is present to assist me
Thank you, Ms.
I
Boyd.
identify those documents and ask that you make them part of the record today.
Yes,
the first document that Ms. Adams is going to distribute to you includes the filing that I made with the Legislative Council, the notice of drafting, and the file stamp copy, the official file stamp transmittal document transmittal form.
Will these documents be marked separately or as one?
Please mark them as one composite exhibit.
Okay, I'm talking about all of them. The notice of drafting and the filing,
I think
the
that you
stamp. Do you want that one as one? Or?
One, please.
Okay. The notice of drafting and the stamped copy indicating that it was filed will be a composite hearing exhibit marked for identification as hearing exhibit 1 and received into the evidence of this case.
The next document, Madam Chair, is the proposed regulation that was filed with the Legislative Council and the official file stamp copy of the document transmittal form.
The proposed regulation and the stamped transmittal form will be marked for identification as hearing exhibit 2 and received in the evidence.
Next, Madam Chair, you will receive 2 verifications. We are required, as you know, to verify the clean version, which doesn't include any struck or underlined language, and another version which does include struck and underlined language. And so these are the 2 verifications I'd ask that you make the next exhibit, please.
I need to see what we're talking about. Ms. Boyd,
Yes, ma'am.
what's been handed up, and I think is supposed to be, what you're offering is hearing Exhibit 3. It says pending corrections.
Correct. So whenever the
Are these
verification at
two
the top,
documents or one?
there are two documents.
Okay.
We are required to verify two documents. One includes specific underlines and strike-throughs. So you know exactly what the agency is asking to delete and what's new. The other version does not include any underlines and strike-throughs. When we file these documents with the Legislative Council, the editor there only wants to receive the top page and any page with changes, not the entire document. And so that's why these documents are much shorter than the proposed regulation Ms. Adams just distributed to you.
Okay, I seem to have the same.
Yes,
Two
so one
copies
should
of the
have
same
page
document.
one and two. The other document should have pages 1, 7, 9, and 11. And if there's any confusion, I have another set.
No, I got it now.
Okay.
Okay, thank you. All right. These documents with pending corrections, two documents, one consisting of 2 pages and one consisting of 4, will be a composite exhibit marked for identification as hearing Exhibit 3 and received into the evidence of this case.
Madam Chair, the final set of documents are those copies of the notice of drafting and proposed regulations, which were actually published in the state register as they appear in the state register. If you were to visit the scstatehouse.gov website and then view this information under the Legislative Council's section of that webpage. The first document, it states drafting notices at the top right-hand corner, the number 7, and Public Service Commission, the name is in the middle. That's the notice of drafting published on November 25th, 2022. The next document on the left-hand side, you'll see the number 14, proposed regulations. The commission's name is about 3/4 of the way down on that page, document number 5177. That is the proposed regulation, as you can see on the footer of that page, South Carolina State Register, Volume 47, Issue 1, January 27, 2023. And finally, the last document is what's contained within the link that appears in the proposed regulations, page 17. There's a link under text. So if you click on that link, that's this final document. It's a copy of the entire regulation, including the proposed struck and underlined language.
And this can be a composite exhibit?
Yes, ma'am, please.
Okay. So the notice of drafting, the proposed regulation, and then the entire regulation available through the link will be composite exhibit marked for identification as hearing Exhibit 4 and received into the evidence of this case. Do any of the parties have any questions about what we've just received into evidence or want to see any of these documents? I think you've probably got them all.
We have extra copies too if anyone
Okay.
wants them, Madam Chair.
If there's any objection, I expect y'all to speak up. Ms. Boyd? anything?
Okay, Madam Chair, I'd like to proceed now with our slide deck that we have prepared for this morning. Ms. Adams has copies for interested stakeholders who are in the room and commissioners and the court reporter. Okay, Madam Chair, Commission staff has some proposed regulation changes in Article 3 electric systems that will be of Chapter 103 of the Commission's regulations. And the first slide, of course, is just reviewing or providing a part of the rulemaking statute that requires state agencies to review its regulations every 5 years. The next slide, I've already reviewed this information with you regarding when the notice of drafting was published in the state register and also when the proposed regulation was published in the state register. Our proposed regulation changes for the electric systems regulation include the list that you see here on slide 4 and a little bit on slide 5. To move forward with the substantive changes that staff is proposing the commission consider to its electric systems regulation, beginning with regulation 103-302. Staff is recommending that the commission consider adding definitions for local office or business office to its regulations and a definition for the word mail, M-A-I-L.
Ms. Boyd?
Yes, ma'am.
Do you want to go through all of these together, or may we receive comments from the stakeholders and parties as we go?
I think that is a more efficient process, Madam
Okay.
Chair, if you would consider receiving comments from interested stakeholders as we go through each regulation.
Will that meet with parties' approval? I just think it keeps all the comments kind of contained for each regulation. Okay. So with regard to the proposed amendment 103-302 to add definitions for local office or business office and for mail, are there any comments from the parties? Hearing none, let's go to the next one.
Okay. Madam
Chair,
Ch- oh.
Chair Belzer, I just was wondering
Mr.
if you wanted us to
Anselmo.
acknowledge consent or agreement or.
That
if
might be
silence is-
helpful. I mean, silence doesn't really show up on the transcript.
Well, then, on behalf of Dominion Energy South Carolina, we agree with the proposed changes in the definitional sections of sub 11 and sub 12 of Reg 302.
Thank you. Duke?
The Duke companies agree as well.
Lockhart?
The Duke companies agree as well.
Thank you. Lockhart?
Lockhart agrees as well. Thank you.
ORS?
No concerns.
Thank you.
The next regulation, Madam Chair, is 103-310. And the title of this regulation is Location of Records and Report. The proposed change reflects the fact that utilities can keep its records either within the state or in an accessible cloud-based or other electronic records retention system. And that is the change.
And then there's a strike of some language unless otherwise authorized by the commission. Is that
Right,
correct?
correct.
Okay. With regard to the proposed change on regulation 103-310, and I'm going down the line and not in the order on the appearance list. Dominion?
Chair Belzer, Dominion agrees with that change. It makes sense from a cost-saving perspective and just modern practice of record retention, so
Thank
looks
you.
good.
Duke?
DEC and DEP agree as well, Madam Chair.
Thank you. Lockhart?
We have no concerns.
Office of Regulatory Staff?
No concerns.
Thank you.
The next regulation, Madam Chair, is 103-330, customer information. And a proposed modification occurs in subsection F, which would allow utilities to maintain rate schedules and other rules relating to the service of electrical utilities on the utilities website and in each local office. Those rules and rate schedules would also be available for inspection or download.
Thank you. With regard to the proposed change to regulation 103-330, subsection F, Dominion?
Dominion agrees obviously with the clarification of the definition of local business office. If you have them, then you can post them there.
Duke?
DEC and DEP agree as well.
Lockhart?
No concerns.
Office of Regulatory Staff?
No concerns.
Thank you.
The next regulation is 103.
Madam Chair,
Commissioner Williams?
can I ask a question at this time?
Yes, ma'am.
Dominion just referenced if you have one, and I might not be following quickly enough, but is that covered? Does that need to be reflected?
Well,
I don't see it underlined.
So may I answer that, Madam Chair?
Yes,
Just to
ma'am.
go back to our definition, and of course Dominion can speak for itself. So if we look at the new regulation on the 103-30211 for local office or business office, I think maybe Commissioner Carol Lee Williams is asking this question. The last sentence for that definition, in the event the utility does not operate a local office or business office, this section doesn't apply.
Okay.
So does that, okay.
Okay. Thank you. I appreciate the
I
clarification.
think in the first line it says also in the event that an electrical utility operates a local business office as well. So I think that's covered. Ms. Boyd?
Madam Chair, under Regulation 103-331, the title of this regulation is Customer Deposits. And you'll find a new subsection C that was proposed in the proposed regulation that was published in the state register, it states that the utility may at its option require a non-residential customer to furnish a letter of credit or surety bond in lieu of any cash deposit that may be required. After reviewing the stakeholders' comments, staff has some additional comments where it supports the comments of one of the stakeholders, Lockhart
I think
Power.
it was Lockhart.
It's two-part, Lockhart Power. There are two sections, A5, which is currently displayed on the slide deck, where this section does begin, in my opinion, Section 5 begins speaking about non-residential customers. I'm going to flip back and forth between the two slides. As Lockhart points out, if the language in Section A5, which is here, is struck, because someone could read it or interpret that section as applying only to non-residential customers, perhaps, even though that sentence doesn't specify that it applies solely to non-residential customers. However, staff does not object to deleting the section in Section A5, which states gives the utility the discretion to use other mechanisms for cash deposits, has several options there. And then creating a new subsection C, which would replace staff's proposal in the state regulation, this new subsection doesn't state whether the customer is a residential or non-residential customer, but still allows the utility, of course, the ability to use different tools to secure deposits.
So really what the staff has updated their recommendation to be is just strike the one sentence from A5 and then put that sentence in in subsection C.
Subsection C.
To
without
replace-
Yes, ma'am, but giving the utility to use that option with residential, non-residential. Really, I say residential, non-residential, but there might be some other types that the utility identifies as for its customers. There would not be any specific limitations under the proposal that Lockhart proposes.
Any question from the parties on this change in what is being asked before we get through?
No questions by Dominion.
Dominion, come.
Dominion had originally in its letter expressed some concern with redundancy in the original proposal, but we talked with Lockhart and were able to understand the intent, which was to give general flexibility to the utilities to do this in lieu of cash deposit. And we're in agreement with what Lockhart proposed in their reply letter and what the staff is proposing now. We think it makes sense.
Thank you. Duke,
We have no objection, Madam Chair.
thank you. Lockhart,
We are supportive of this and appreciate the staff and the commission's consideration.
thank you. Office of Regulatory Staff,
Madam Chair, I think we haven't really weighed in on this, but I think that the concerns that we would have would just be from a customer perspective as far as clarity as to the conditions under which that would be applied. I think it's somewhat arbitrary about whether or not there could be a security deposit or under what circumstances. I understand the current regulation addresses some of that. But I think my understanding is that when Lockhart, I think, proposed some of this language, it was relating to customers that were in a financial distressing situation. And we think that it could lead to some customer confusion about when that would be possible. So I don't really have a resolution to that, but that would at least be our concern from that standpoint.
Mr. Mustin, will you yield to a question?
Absolutely.
Would the requirements or the listings in subsection A of when a deposit may be required, would that not say when the deposit that provides the utility with the mechanism of when to determine the deposit is due? And then, as I was reading it, and correct me if I'm wrong, C just provided a little more flexibility than just providing a cash deposit. I understand that sometimes customers are burdened with coming up with the amount of cash needed.
I think it's in the context of the way we read it is it's in the utilities option as opposed to the customer's option. And so I think if it was, the utility may accept or something along those lines, that may resolve some of that concern. But I think just depending upon how it's applied, we could envision customer complaints coming through. I mean, under that situation, we obviously would investigate and would work with the company to try to come up with a solution. But
And you're looking at the language in the new C, that sentence that was taken from 5 and made into subsection C, and you prefer to use the word the utility may accept versus use?
so I think I'm looking now at the PowerPoint presentation. Is that the language you're looking at under the new C? Is that correct?
Yes, sir.
And I apologize if I'm
That's okay. We got a lot of documents flying around here.
right.
Madam Chair, if I could clarify, if you don't mind.
Ms. Fox?
Lockhart's concern was, and what the original proposal was to have language saying that the utility may, at its option, require a non-residential customer to furnish a letter of credit or surety bond in lieu of the cash deposit. So Lockhart's concern with saying that the utility may accept would be that the utility needs the flexibility to require that from a larger customer. Now, I understand Mr. Muschin's concern that from a residential customer, it should be at the residential customer's option. But the original intent was to have this language apply to non-residential customers and give the utility flexibility there, not to apply to residential. And it may be that maybe we just keep this language but specify, because it came out of a section that dealt with non-residential customers. So maybe in this new C, maybe make a reference to non-residential customers in C so that intent is clear. That could be an option.
Mr. Muschin?
I mean, I apologize. So
No.
part of this, I'm coming in on the tail end of this. So Mr. Knowles was supposed to be here today and unfortunately had an issue. So I'm winging this as we go. But I think the language that was originally proposed, I don't think we had a problem with when it was in the context of in lieu of a cash deposit. This seems to be more in the context of the utility can elect it. I don't know that it would be applied arbitrarily. I don't think it would be, I'm sure, but I think just the language is written caused us some concern just from the customer standpoint as to when that would apply and when it would not. Maybe if it was in lieu of the payment of, or maybe if it was the utility may accept a variety of security options, or may offer a variety of security options, subject to the provisions of subsection A, that may alleviate some of the concerns. I don't know that this is a strong concern. That was just our reaction to it when we saw it.
And Chair Belzer, in our conversations with Lockhart as we worked through what the intent was, it was in fact, as Ms. Fox said, to be non-residential. So the Dominion would suggest that the sub C on the slide deck just have an introductory clause that says for non-residential customers, comma, the electrical utility may do this. And I think that alleviates ORS's concern and brings us back to the intent of the original proposal from Lockhart.
I think I understand that the original intent was for non-residential, but I mean, there are customers that, residential customers who have trouble meeting the deposit requirement. And I mean, I don't know that residential customers would be able to really get a surety bond or a letter of credit. Those are instruments that are probably geared more toward a non-residential customer. But there are some concerns there. Ms. Fox, did you have something else you want to say?
Yeah, I was just going to point out that A2 deals with residential customers and some flexibility there. They can use a letter of good credit from an electrical utility or references or a cosigner or guarantee. So the flexibility for the residential customers, I think, is
It's
there,
already there.
that then you require a cash deposit if they can't do any of those. And this, with the letter of credit and, whatever other options there, are more geared toward non-residential customers.
Okay.
So I think both are covered.
Madam Chair,
Commissioner Caston?
I feel like I'm watching a tennis match and I think I know who's ahead. So I want to make sure I've caught up. A2, in your view, Ms. Fox, kind of covers the residential aspect. A5 is for the non-residential, which, could be commercial, industrial, whatever. It is for that section. And, Mr. Meston, if the paragraph C is added that is specifically relative to non-residential along the lines that are in the slide presentation, is that a distinction that's clear enough for ORS you think that covers any concern you may have?
Well, I may be able to even short circuit that even more. And I don't think I understood, and now I do, that if Dominion and Lockhart are fine with it, then I think we're okay with it.
I think I finally got it all too, so I appreciate everyone doing that. Thank you.
Chair Belzer?
Commissioner Carolyn Williams?
Looking at A2 more closely, this is a brand new idea, but as I read that, I don't see where that is clearly about residential customers. And does that need to be clarified?
I was going to ask, Madam Chair, if the intent for C, because I did not read it, I appreciate Ms. Fox and Mr. Anselmo's responses, if that's only going to be restricted to non-residential, perhaps for non-residential customers be included there?
In C.
In C, yeah, because I did not, that's my, that was just my reading at the time.
And
I read it broader than, and I'm glad they spoke up this morning.
Commissioner Williams, if to your specific question about subsection A2, in subsection A, the introductory clause to those 5 subpoints, it says any customer. So Dominion believes that any customer would encompass any class of customers, and sub 2 would therefore include residential customers.
Right. I thought that we were trying to clarify that, and maybe I didn't keep up, that A2 was for residential customers and that C was for non-residential customers. And if we're going to clarify that C is for non-residential, why not clarify that A2 is specifically for residential?
But A2 could also apply to non-residential customers.
Okay. Then I have one other tiny element. And that is, I think I read somewhere that the intent was to, where there was a gender reflected in the language to clarify. So I note that it says a new customer cannot demonstrate that he, should that be changed to
The
say
customer.
that they are?
Or the customer. A new customer
Right.
cannot demonstrate that the customer. Yes, ma'am.
I would suggest that then.
Yes,
For
ma'am.
consistency.
Where is that in the?
A2, in the first line, a new customer cannot demonstrate that
And
the customer is?
there's also a his in A4. I don't know that we'll be able to.
There?
We've been in the changes, we've just been stating, a customer or the customer or customers, Commissioner Williams, but however the commission wants us to change the language. That's just the way we've addressed it.
So you suggest in 2 that instead of he, it says what?
Just a new customer cannot demonstrate that the customer has a satisfactory I'm sorry, that the
Is-
customer
Is a satisfactory.
is a satisfactory credit risk. And then in 4, a customer has not had the customer's service terminated.
No,
That's-
should it not be? It would be a customer service. A customer's service has been terminated for non-payment or fraudulent use. Shouldn't that be the language? If any of the following conditions exist, a customer's service has been terminated for non-payment or fraudulent use.
Okay. That's fine too, Madam Chair. What we've just tried to do in the regs, not just this section, but others, is not move the language around too much, just strike the pronoun, but however you want to reword it is fine. Strike the pronoun.
Well, I mean, would it be a customer has had service terminated for non-payment or fraudulent use? Does that make equal?
Has had
Sense.
service. I think in that situation, that will work, just deleting the HIS, the word HIS.
Stakeholders, y'all see any problem with just deleting the pronoun?
Madam Chair,
Commissioner Caston?
if we're trying to be, I guess, gender neutral throughout the regulation, I'm not sure. And yeah, I'm certainly fine with that. What concerns me is trying to do these kind of things. I believe could potentially lead to a challenge in interpreting the sentence sometimes. I mean, it's almost, will it become redundant? Do we need to say a new customer cannot demonstrate that the new customer is? I'm not sure we shouldn't hit the pause button on that maybe a minute and just kind of think a little more deeply about that, because if it offends somebody, let's, deal with the offense, but I'm not sure it's wise to just arbitrarily just say, let's take out all the pronouns.
Yeah, we've tried, when they are gender specific, Commissioner Caston, in our review, we've tried to catch as many as we can that are gender specific, only because a reference was made to that in one of the workshops we had, to please try to review the regs for gender specific.
Well, I don't
notes.
I don't certainly mean to challenge that or disrespect that at all, but maybe in a great suggestion, but it may not be the best suggestion. So that's all I'm suggesting,
Yes, sir.
is before we do anything like that, is that the best thing to do? And I can't answer that question. I'm just asking that question right now.
Are you ready for me? Oh, Commissioner Williams, Madam
Caston,
Chair.
is your concern making these two changes on the fly, or the overall question of changing gender to gender neutral?
Probably the overall, only because I see how we're struggling with this, and frankly, I am too. It's like, I'm not sure what's the best way to word that. It's not redundant, confusing, or, look, if you want to put her, it's fine with me. I mean, I don't really care. But I just think we need to tread carefully in just eliminating long-held use of pronouns to define and describe things. That's all I'm saying. I don't care what the gender is.
Commissioner Caston, I understand your concern as somebody who's done a lot of litigation over intent of sentences and statutes and regulations. It's important. Obviously, we're workshopping some of this on the fly, and one idea the company had actually kicked around was perhaps a definitional change in the definitional sections that defines whatever pronoun is used in a gender-neutral way. So the pronoun would remain in each regulation, but the definitional sections would define inclusivity of all genders in the definitional section. So the his would stay, for instance, in sub 4, but the definition would mean male, female, whatever, however you want to define it. That way you don't have to change any of the sections specifically. Again, just an idea, but one that might solve the problem.
sounds like a really good suggestion to me. You know, may want to consider that. You know, I think that might be wiser, but I'll defer to the rest.
Madam Chair, Commissioner Carol Lee Williams.
Oh, Commissioner Williams?
Chair Belzer and Director Boyd, perhaps it would help to review what the next steps are, because we are kind of doing this on the fly. But we're not going to take a vote at the end of today's hearing. So we have some time. Could you review what those next steps are so we understand the time that we have to understand intent today, but to get the words right when we make a decision?
We have to consider the record before that's coming out of this proceeding, and the record can consist of the written comments previously submitted in this docket and any suggestions, edits that come out in this proceeding today. And then we also have to hold a record open for at least 5 days after today that additional comments may be submitted. And those can be considered. So, but the ultimate regulation needs to be based on either the written comments that have come in before, what's coming in today, or comments that may be submitted after the hearing. Am I missing anything, Ms. Boyd?
No, ma'am, you're not.
Or any of the parties? Anybody want to correct me? It's fine.
Madam Chair.
Commissioner Williams?
Madam Chair, I just want to ask Commissioner Carol Lee Williams a question. When you say we're doing this on the fly, I understand I guess the colloquial use of that phrase, but we can take our time. I don't want you to feel like we're rushing through it.
And that was the point of my question. I really was quoting someone else in the hearing room in talking about, I think there was a moment in this conversation where it felt like we were trying to really get specific language that we could accept and move on. And I think the clarity is that we can take the wisdom of what we're hearing throughout the room and then make a decision before the business meeting where we make these changes. So I appreciate the question, and I think we're in the same, we're both trying to make the same point different ways.
Understood. Thank you, ma'am.
Any further comments on 103-331 customer deposits and pronouns? Ms. Boyd?
The next regulation, Madam Chair, is 103-333. Thank you, Ms. Purvis. The title of this regulation is Interest on Deposits. And the proposed change would include language that states interest on deposit shall cease when the deposit is no longer required, and also the main mechanism or means by which the utility will notify the customer that interest has ceased on that particular deposit. By bill insert, by notice method, selected by the electrical utility customer and maintained in the customer's records at the electrical utility. I think those are the only two changes.
Thank you. Any comments or issues with this change, Dominion?
No concerns.
Duke?
No concerns from Duke.
Ms. Fox?
No concerns.
ORS?
No concerns.
I have a question about a bill insert, because this isn't going to be a whole bunch of customers, is it? I mean, I just kind of wonder about the bill insert. Would that include?
Well, I think
would that include like a note written on the bill,
or just however they want to prepare it. It's a typed statement, but it doesn't. To me, that says that the notification does not have to be made by separate mailing. It can be included in the customer's bill.
Okay, that's clarification.
Okay. The next regulation, Madam Chair, is 103-339, customer billing. And the proposed new language in section 2K requires the telephone number and email address of the Office of Regulatory Staff to appear on the bill. There were some comments made, I can remember, by Duke, and I can't remember if Dominion asked or not, I just don't remember. Sorry, I apologize. About, what email address should be used on the utilities bills for the Office of Regulatory Staff. And so the Office of Regulatory Staff responded, and staff has included a proposed, I wouldn't say a change, but perhaps a recommendation and that's on slide 14. If the commissioners adopt this proposed change in 103.339 section 2K, the commissioners consider including the Office of Regulatory Staff's current consumer services email address, complaints@ors.sc.gov, and telephone numbers in the commission's order if this regulation is promulgated. If the Office of Regulatory Staff needs to modify its contact information in the future, it can notify the commission, and the commission can dispose of its request at a commission business meeting and through a commission order, instead of placing that information in the regulation, because ORS's numbers can change and that email address can change.
So is the proposal just to add the second bullet, or?
The proposal is still to add the language in, well, I wouldn't recommend, I don't think that you would need to instruct ORS in a regulation, Madam Chair, to change its contact information with you or notify the commission. But I think if you place that in the order, if the order states we've promulgated this regulation, if the General Assembly approves and it becomes effective, then utilities will use the following contact information on its bills so that customers can notify the Office of Regulatory Staff.
Okay.
That's what I mean.
All right, but as far as the proposed regulation, the language in K, which states the telephone number and email address of the ORS, would remain unchanged.
Yes, ma'am.
And, okay. Dominion comments?
We thank ORS for providing the information we requested, and we're fine with the proposed language in sub 2K.
Okay. Duke?
DC and DEP likewise thank ORS for providing the information, and we're okay with the change.
Lockhart?
We have no concerns.
Mr. Mustian?
No comments.
Thank y'all for the letter that ORS filed, and ORS knows that if they're gonna end up with different email or number to notify the commission and the parties.
Yes,
Is
ma'am.
that correct?
Yes, ma'am.
I have a feeling that would apply to people other than electric utilities.
I'm sure we would let everybody know that. Yes, ma'am.
Thank you, Mr. Mustian. Commissioners, any questions? Ms. Boyd?
Okay, Madam Chair, the next regulation is
Madam Chair, could I just hold one?
Commissioner Caston?
I want to make sure I've got this. I don't want to complicate anything that doesn't need complicating. In the letter we received from ORS April 4th, and the contact information we just had, I guess, looking at it, was it proposed? Am I misunderstanding this? Is it proposed in the regulation in that paragraph K that the Consumer Service Department of?
The proposal is just that the telephone number and email address of the Office of Regulatory Staff. It is not specifying an email or a telephone number.
Okay.
ORS, I think in response to Dominion and Duke and maybe Lockhart, filed a letter advising them of the email address to use and the telephone number for their consumer services division is what I think happened. But ORS in their letter did not ask that that specific email address or telephone number be included in the regulation. Is that correct?
Correct, and I would not recommend that we include the number in the regulation because obviously that would require, if we did have to change that or email address, that would require a longer process. So I think the language that's in the proposed regulation is good. I think my understanding, Ms. Boyd's suggestion was y'all would include that information in the order, and then if we needed to change that down the road, that could be more easily done through a commission order directive addressing that at that point.
okay where we're doing it, correct? Well, I don't think so either. I'm okay. Thank you, Madam Chair. No more questions.
Thank you, Commissioner Caston. Ms. Boyd?
Okay, Madam Chair, the next section is 103-340, adjustment of bills. I'll note that in section 1B, we did add the numbers for a reference, a numerical reference for the number 60. You'll see that's underlined. But the more substantive change here is that if a utility willfully overcharges a customer, that the customers, that charge, that excess will be adjusted for interest as provided in South Carolina Code of Laws, Section 34-31-20A. Oh, and then there is another substantive change. So we learned during the workshop for equal payment plans, that's over under Section 5. There's some language that currently reads, it's the second sentence, the difference between the actual and estimated annual bill is to be resolved by one payment at the end of the equal payment plan year unless otherwise approved by the commission. And so the reason for proposing this, that language be struck, is to allow the utility flexibility to give the customer more than a year if the customer needs that time to pay the difference between the actual and the estimated amount of the equal payment plan. So instead of limiting the customer to,
Chair Belzer?
Commissioner Carolyn Williams?
Thank you. This is just a curiosity. When would a customer willingly be overcharged?
Willfully.
Williams,
Not,
sorry,
will,
go ahead.
not willingly, but
It's
willfully.
Yeah,
That
willfully.
That means through some intentional conduct of the utility. So, I'm not aware of any of my clients, of course, ever doing that. But people can be accused of it from time to time, I suppose. And if they can prove it, then it is a wrongful overcharging. For example, if you were overcharging a customer and they told you and you investigated it and then you didn't fix it or whatever, I mean, there could be a willful overcharging of a customer. And in that case, that's wrongful conduct and should draw interest at the higher rate, the rate allowed by law. So, I mean, Lockhart agrees with those changes.
And Dominion is not aware of this ever occurring on Dominion, but we agree with Lockhart that in the event it does, this interest rate proposed in the statute is reasonable.
And the Duke companies agree. Thank you.
thank you, just curious.
ORS?
Agree.
Agree? On that section, how about with regard, I don't think there's an issue with adding the numerical 60, but what about the equal payment plans? Dominion, any issue with striking that language?
No, that actually reflects the practice that the company does now anyway, so we're perfectly fine with that.
Duke?
None of which I'm aware, Madam Chair.
Okay. Lockhart?
No concerns.
Office of Regulatory Staff?
No concerns.
Thank you.
The next section, Madam Chair, is 103-352, procedures for termination of service. We have a small change to replace the word house
Yeah.
with the word house with the word hours, and then to make some gender neutral changes.
Okay.
That's all I have on that, Madam Chair.
Dominion?
No concerns.
Duke?
No concerns.
Lockhart?
No concerns.
Office of Regulatory Staff?
No concerns.
Commissioners?
Okay, Madam Chair, the next regulation is 103-370. The title of that regulation is Electrical Utility Inspection and Test. And the proposed change here is to correct terminology in the regulation from Code of electricity meters to Code 4 electricity metering. And there are also there's a proposal to strike certain pronouns and replace those pronouns with the customer or the customers. And those are the proposed changes there.
Okay, with regard to the edits to 103-370, any concerns?
No concerns.
Dominion, Duke,
No concerns.
Lockhart,
No concerns.
Office of Regulatory Staff,
No concerns.
Commissioners,
Chair Belzer,
Commissioner Williams.
I think that Duke may have talked about modernizing regulations with regard to this section, and I was just curious if there was more, if you wanted us to have more of an understanding about that. I'm looking at the March 1st letter.
Sure. Commissioner Williams, I'm not aware of any specific concerns with the language as proposed at this time, but would be happy to reach back out to the client and submit a follow-up letter to the extent that's necessary. But appreciate the question and the opportunity.
Was it on, Commissioner Williams, was it on this regulation, 370?
It appears to be March 1st, 2023, a letter from Katie M. Brown.
In the most recent letter that I have, Commissioner Williams, which is dated April 6th, didn't see any of those concerns as outlined in this particular provision.
And I saw that as well. I just wanted to be sure that,
Well, I think what is accepted, or what the staff proposed, was actually part of Duke's recommendations from the April 2021 workshop that changed the name from Code of Electricity Meters to Code for Electricity Metering. I think that did accept what Duke had proposed with regard to that item.
I see other elements, so I think that Mr. Vorden's offer to review and come back to us, it may have been resolved during the process, and I'd be happy to hear that as well.
Mr. Traywick, do you mind
I'm sorry.
submitting?
Sure. I will submit a follow-up letter and address any concerns.
Thank you.
But,
Sorry about that, Mr. Traywick.
Not a problem, Commissioner Williams. But the language as proposed, we're fine with.
Okay, that is good enough for me, so forget the follow-up letter.
Okay. Thank you.
Any other questions regarding 103-370, Commissioners? Okay, Ms. Boyd?
Okay, Madam Chair, the last regulation is 103-392, and it's just to correct a misspelled word, the word in section D, liaison. And
Anybody have an issue if we spell a word correctly in the regulation? From someone that is spelling challenged, I can appreciate this slipping by during the process.
I feel bad that I didn't even notice it was misspelled because I'm that bad at spelling, so.
Well, I didn't either, and that speaks to me as well. So Dominion's okay, Duke,
It was a good catch. Thank you.
Lockhart, no problem. ORS,
No
thank
concern.
you. Commissioners? Okay, Ms. Boyd?
I don't have any other comments, Madam Chair.
Have we missed anything? Are there any concerns from any of the parties that we haven't addressed on what was in the proposed regulations? Commissioners, any questions for anything we've gone through? Oh, Mr. Elzema?
I was just going to say, we appreciate the opportunity. I think y'all have covered what the company had originally put in its letters, and thank staff for its time and attention to this revision process.
Thank you.
I'd
Mr.
echo
Traywick?
that too, Madam Chair, and appreciate the collaborative process.
That helps. Ms. Boyd, is there anything else? I'm sorry, Ms. Fox, did you have something?
No, just agreeing that we appreciate the opportunity to participate.
Well, I can only speak for one commissioner, but I think that I think we all appreciate the work that all the parties put in to the stakeholder engagement process and the workshops, and appreciate everybody's careful attention to make sure that these are as clear as we can make them. So. Now, Ms. Boyd, we need to hold the record open for an additional 5 days. Is that correct?
Yes, ma'am, and I think it's 5 business days.
Business days. That's what. Yes, and so today is Wednesday, so that'll be Thursday, Friday, Monday, Tuesday, next Wednesday, which would
Next
be.
Wednesday. Yes,
Is that the 12th?
that's correct.
So anybody wishing to file any follow-up comments, please do so by close of business on Wednesday, April 12th. And if there is nothing further from commissioners or parties, we are now adjourned. Thank you very much.